Hello, everyone. Welcome to Save News TV. I am your host, AZ Hubbard, and thank you for allowing us into your homes today. Well, a couple of things I want to do a little bit of house cleaning first before we get into the case of TD Jakes versus Duane Youngblood. First, over here, when we cover a case, we read the documents. So we have some new viewers that's on now. Well, and make sure you like, share, and subscribe. But anyway, when we're covering a case, we're reading the most current documents. So you're not going to see both sides. You'll see one side, whoever filed their motion, or whether the judge has ruled on a motion. Then you will see the response, until a verdict is given. So you have to follow along with the case on every video. So the reason why I'm saying this is because I just did a Dr. Phil's company versus TBN and TCT. And I had someone respond, well, we want to hear both sides. Well, I can't give you both sides because at one time, and nobody can, because once a motion is filed or a lawsuit is filed, the court is entered in, then the defendants are given a certain amount of time to respond. And so we're just reading one part, and then once it's filed, we'll go back and read the other part. We do keep up with cases on all filings, so we want to make sure people understand how, when we say we're covering a case, that's how it's done. And we will have a playlist on our um, page here, so you can start from the beginning and follow all of it. So I'm a little up in the air whether or not we're going to follow the Dr. Phil versus TBN and TCT case, because it seems like there's some confusion within the commenters, the new followers, not all, but just a few, of how a case is covered. So get in the comments and let me know about that if you happen to watch that video. I'm going to put it in the playlist, also that video, and see whether that particular case interests you. So if that case interests you, then we might, we'll go ahead and follow that case. All right, then. So now that we have gotten that air cleared in the air, we're going to move on to TD Jakes versus Youngblood case. There's a couple of things that has happened in that case, and so we're going to talk about it right now. Okay, so everybody, the first thing that happened to in this case last week was, well, not the first thing, well, the first thing that happened last week, but in continuation, is that TD Jakes made a motion, his team made a motion for Amy McCain Rollins admission as pro hoc vice to be added to the case as far as an attorney to represent him. Now, pro hoc vice means that this person does not live in this state and they're coming in from a different state to represent them. I would really go over the person and their background. However, I'm going to read this because it's a part of the case, but it was terminated. So we don't know the reason why it was terminated. This motion was terminated, but it was terminated by the court. So until we get some clarification on that, um, we're just going to say that this particular person, even though they filed pro hoc vice initially to come onto the case as a part of TD Jake's team, we are not adding her because of the fact at this moment it was terminated. The judge did put in an order ruling on this particular motion. However, it is not available to the public. Okay. So it was put in on the 8th of July. The courts terminated the motion on the 9th. So, but anyway, we're going to go read who, and I'm not going to go over her background. If we need to come back and visit her, we will. We really want to get into the response portion of it. So this is the motion. Amy McCain Roller, undersigned counsel for plaintiff Thomas Dexter Jakes, hereby moves that Amy McCain Roller be admitted to appear and practice in this court as counsel pro hoc vice for plaintiff Thomas Dexter Jakes in the above captioned case. In support of this motion, undersigned counsel attaches the declaration for admission pro hoc vice for Amy McCann Roller, filed here with which it is averred satisfies the requirements of the foregoing local rules and standing order. So that is pretty much it with that. Remember, everybody over here, we do not have a dog in any fight. We just read the cases. It is up to you. You can root for one team or the other. We're just going to give you the facts. I'm going to make commentary in between sometimes, and the only reason why I'm making commentary is because I am commenting on the validity of either side. So Save News don't have a dog in any fight, but let's get on now to the actual case of the response that Duane Youngblood did for the last motion that we had.
Defendant Duane Youngblood's answer and affirmative defenses. Defendant Duane Youngblood, by and through the undersigned counsel, hereby files his answer and affirmative defenses to plaintiff's complaint, and avers as follows. Nature of the action. Paragraph 1 states a legal conclusion to which no response is required. To the extent a response is required, Youngblood denies the allegations of paragraph 1. Denied. Not only is defendant without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 2, but Mr. Youngblood vehemently denies any plan, much less any conspiratorial conduct regarding an attempt of extortion. Defendant is the defendant, not the plaintiff. There is no action filed nor any formal or informal request or demand whatsoever from the plaintiff for millions of dollars. Denied. Defendant without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 3 regarding plaintiff's motive for filing the lawsuit, further denied in that the paragraph calls for a legal conclusion regarding the alleged falsity of the accusations, and to the extent that a response is required, Mr. Youngblood is fully prepared to stand on the truth. Parties. Defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 4, and cannot speak to plaintiff's proclamations of the scope and breadth of his professional resume. Admitted that defendant is a U.S. citizen and resident of the city of Pittsburgh. Denied as to the remainder of the paragraph. Denied. Not only is defendant without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 6, but Mr. Youngblood vehemently denies any plan, much less any conspiratorial conduct with any John Does. The remaining portion of the paragraph does not require a response regarding plaintiff's alleged intentions to amend the complaint. Denied. Paragraph 7 states a legal conclusion to which no response is required. To the extent a response is required, Youngblood denies the allegations of paragraph 7. To the extent a response would be required, not only is defendant without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 7, but Mr. Youngblood vehemently denies any plan, much less any conspiratorial conduct of any sort, and stands on the truth of the underlying merits of this case. Jurisdiction and venue. Denied. Paragraph 8 states a legal conclusion to which no response is required. Defendant relies upon the court to make its own determination regarding jurisdiction. To the extent a response is required, defendant strongly denies that there is any amount in controversy whatsoever. Denied. Paragraph 9 states a legal conclusion to which no response is required. Defendant relies upon the court to make its own determination regarding jurisdiction. Factual allegations. Denied. Paragraph 10 states a legal conclusion to which no response is required. Defendant relies upon the court to make its own determination regarding venue. Denied. Defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 11, and cannot speak to plaintiff's proclamations of the scope and breadth of his professional resume. Denied. Defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 12 and cannot speak to plaintiff's proclamations of the scope and breadth of his professional resume, and is unfamiliar with, for example, the scope of his inspiration upon others or how he spent his personal spiritual devotion journey. Denied. Defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 13 and cannot speak to plaintiff's proclamations of the scope and breadth of his professional resume, and is unfamiliar with, for example, alleged philanthropic efforts or speaking engagements. Denied. Defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 14 and cannot speak to plaintiff's proclamations of the scope and breadth of his professional resume, and is unfamiliar with, for example, the particulars of plaintiff's marriage or the accuracy regarding claims of the integrity of his reputation. Denied. Paragraph 15 states a legal conclusion to which no response is required. To the extent a response is required, Youngblood denies both the characterization of the paragraph's averments and the self-serving precursor of there being a stark contrast between the parties. Denied. Defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 16 and further denied in that the paragraph calls for speculation about events that did not transpire and further denied in that, even if true communications of the intent of a parishioner would be privileged context. Admitted. Denied. Paragraph 18 states a legal conclusion to which no response is required. The contents of this paragraph are mired in speculation and conjecture, and further denied in that communications regarding counseling between defendant and a member of the parish would be privileged. Denied. Not only is defendant without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 19, but Mr. Youngblood vehemently denies any plan, much less any conspiratorial conduct with anyone. Denied in part, admitted in part. Defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph and is unfamiliar with, for example, the public viewing audience or associated metrics of Larry Reid's program. Admitted that defendant participated in an interview on the television program. Denied. Paragraph 21 states a legal conclusion to which no response is required. The contents of this paragraph are mired in speculation and conjecture and further denied in that communications regarding counseling between defendant and a member of the parish would be privileged. Paragraph 22 states a legal conclusion to which no response is required. The contents of this paragraph are mired in speculation and conjecture and further denied in that communications regarding the abuse defendant sustained at the hands of Bishop Jakes is far from new. Admitted that a portion of the interview was spent discussing Bishop Jakes' actions as they pertain to Mr. Youngblood. Denied as to the rest. Admitted that Youngblood shared a story about his experience with Bishop Jakes and the sexual abuse that attended the interaction. Admitted that Bishop Jakes called Mr. Youngblood the next day with additional sexual and inappropriate grooming, and that this experience was shared during the interview. Admitted that during the interview Mr. Youngblood explained to a certain degree the impact the abuse had upon him, and recalled his mother making him go to church that night. Admitted that Mr. Youngblood recounted a conversation with Bishop Jakes about the abuse. Admitted that Mr. Youngblood participated in part 2 of the interview and shared his perspective about Bishop Jakes' actions and how they relate to sexual assault. Admitted that Mr. Youngblood shared his impression about a disturbing phone call with Bishop Jakes. Admitted that the interviewer, Mr. Reid, characterized Youngblood's experience with his own commentary. Denied. This paragraph is replete with speculation and hyperbole regarding the intention of the interviewer, and an alleged intent by Mr. Youngblood regarding the interview itself. Denied. Paragraph 32 states a legal conclusion to which no response is required. To the extent a response is required, Mr. Youngblood unequivocally asserts and stands by his allegations that the sexual misconduct described during the LRL interviews are true. Period. Denied. This paragraph is replete with speculation and hyperbole regarding the intentions of Mr. Youngblood, and a self-serving theory about why he spoke his truth. This colorful theory is an obvious attempt to undercut Mr. Youngblood's credibility, and in the same vein distract from Bishop Jake's conduct, by engaging in characterization of the defendant. Denied. This paragraph is replete with speculation and hyperbole regarding the intention of Mr. Youngblood regarding the interviews and further denied in that defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph and is unfamiliar with the scope of the public viewing audience or associated metrics of Larry Reed's program. Denied in that defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph and is unfamiliar with the scope of the public viewing audience or associated metrics of Larry Reed's program. Denied in that defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph and is unfamiliar with the scope of the public viewing audience or associated metrics of Larry Reed's program, or impact on other social media users.
Okay, number 37, denied the scope. He goes on, he doesn't know the public viewing audience or associated metrics with the program and impact of other social media users. This paragraph is also mere speculation. 38, he denies the paragraph 38 is legal conclusions to which no response is required, and further denied in that defendant is without sufficient knowledge or informational knowledge to either admit or deny allegations contained in paragraph 18. But Youngblood vehemently denies any plan, much less any conspiratorial conduct with any legal representative, and in fact has not made any financial demands on the plaintiff whatsoever. Okay, hold up. We just discussed the demand letter. So that is a financial plan, a financial demand on the plaintiff. So, we have to also state that, let me see, 38. Let's see. We want to also state, we're at 38. So this is not filed by his regular attorney. Th- this is filed by the attorney that he is going under the ad hoc vice. Okay. So remember that um Blackburn is his regular attorney, and this attorney that is filing this is the attorney that has the law firm in Pennsylvania that Blackburn came under in the ad hoc vice case. Okay. So remember that. So this attorney here, he might not be totally familiar with everything, the filing, because it was, uh tough on the case because the judge is on Blackburn's um tail because of the filings that he gave previously. And also this week and next week, there are other things, consequences, that Blackburn might lose his attorney license or be punished by the court. So this particular attorney, to save his grace and his firm, now is stepping in and answering these questions. Okay. So 38 paragraph states he's denied. Okay, we just read it. 39 denied, and he says admits or denied the allegation contained in paragraph. But Youngblood vehemently denies any plan, much less any conspiratorial conduct with any legal representative, and in fact has not made a financial demand upon the plaintiff whatsoever. Didn't he just, it's the same thing. Okay, 30, 39, 40 is the same thing. 38, 39, 40 denied. Excuse me. To the extent to respond to the required defendant is not an attorney and is completely unfamiliar with the federal criminal law. Number 41, he denies defendant is not an attorney and is unfamiliar with Pennsylvania law as it relates to extortion. Okay, so those are some serious things. 43, he denies to the extent to the response required. Youngblood vehemently denies any plan, much less any conspiratorial conduct with the legal representative, and in fact has not made any financial demands of the plaintiff whatsoever. Further denied that Youngblood is unfamiliar with any attorney's background regarding demands upon celebrities. Well, when you hire an attorney, you should do your due diligence. But okay, he denied it, so it is what it is. 44, he denies to the extent the response required. Youngblood vehemently denies the extent of any plan, excuse me, and the fact that no financial demands was made of the plaintiff whatsoever, so they cannot possibly be a playbook. Okay. Okay. 45, he denies, and the Youngblood vehemently denies any plan, and the plaintiff's theory is severely undermined by the fact that Youngblood has not made any financial demands upon the plaintiff whatsoever. So there cannot possibly be an intention to profit significantly. Come on now. There was a $6 million demand letter prior to the case being filed. So even though he hasn't profited and didn't get any money, he did request it. And well, the request was made on his behalf by Blackburn. Number 46, denied. He says knowledge and either admit to deny the allegations contained in the paragraph 46 regarding plaintiff's reputation or spiritual impact, and has certainly not engaged in any conspiratorial acts to the extent to a response is required. Mr. Youngblood's claims regarding abuse by the plaintiff are not isolated. Number 47, he denies regarding the plaintiff's reputation or philanthropy, further denies that there are any connection between Mr. Youngblood's interview on Larry Reed Live and any medical condition associated with the plaintiff. Number 48, he denies. Um, he says that he denies the defendant is without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 48 regarding the plaintiff's value system regarding the victim's SA. He denies defendant is without sufficient information and knowledge to either admit or deny the reasons why the plaintiff brought the lawsuit. Okay, the claims for relief. Libel per se against the defendant, Duane Youngblood, paragraph 50, is merely an incorporation paragraph, and no response is required. To the extent a response is required, Mr. Youngblood incorporates the entirety of the responses in all preceding paragraphs. 51. He admitted that on October 28, 2024 and November 3rd, 2024, Youngblood recounted during a live interview on Larry Reed Live's show instances of SA at the hands of the plaintiff. 52, he admits that Youngblood made a specific statement outlined in paragraph regarding plaintiff SA abuse. Number 53, he admits that Youngblood made the specific statements outlined in the paragraph regarding plaintiff's SA. Number 54, he denies as without sufficient information and knowledge in either admit or deny the allegations regarding the plaintiff. social media platforms, if any, are utilized by Larry Reed Live, which excerpts, if any, the producers chose to air, and what the metrics are regarding viewerships. Okay. Number 55, he admits that Youngblood made the statements concerning plaintiff. Number 56, he denies that plaintiff is without sufficient information or knowledge to either admit or deny the allegations, the plaintiff's speculations about how the interviews were interpreted by the viewers. Number 57, he denies Mr. Youngblood's statements on October 28th and October 3rd. This is an error. It should be November 3rd. Um, Episodes are completely true and therefore cannot possibly be defamatory or false. Number 58, denied in that the plaintiff, without sufficient information or knowledge, can either admit or deny the allegations contained in paragraph 58. Number 59, um he denied in that the defendant is without sufficient information and knowledge to admit or deny the allegations contained in paragraph 59 regarding plaintiff's reputation. Okay. Well, if you make something some allegations, it's going to probably affect anybody's reputation. Excuse me. Number 60, he denies that the legal conclusion, including regarding malice and intent, to which no response is required. To the extent a response is required, Mr. Youngblood's statements are not false. Number 61, he denies, to the extent that the response is required, Mr. Youngblood's statements are not false. Further denied that Mr. Youngblood made no financial demands upon the plaintiff, and therefore the theory floated by the plaintiff is severely undermined. Number 62, he denies, to the extent a response is required, statement is false. Number 63, he denies, to the extent that a response is required, the statement is false. Further denied that the defendant is without sufficient information or knowledge to either admit or deny allegations contained in the paragraph 63 regarding the plaintiff's reputation. Number 64 is denied. Further denied that the defendant is without sufficient information or knowledge to admit or deny allegations contained in paragraph 64. Denied, to the extent a response is required, plaintiff cannot possibly be entitled to damages because there is no liability. So in other words, they're arguing, we didn't do, say we said this, but we cannot be held for defamation because, the defense for defamation is the truth, and they're saying that Youngblood is telling the truth, so he cannot be held liable. Okay, and he did not defame TD Jakes because he is telling the truth. So that's pretty much all of that what it's saying. Okay, 66. To the extent a response is required, Youngblood incorporates the entirety of his responses in the preceding paragraphs. 67, denied. To the extent that response would be required, not only is the defendant without sufficient information or knowledge to either admit or deny the allegations contained in paragraph 67, as to the metrics of the podcast viewers audience, but Youngblood denies any plan, which much less any conspiratorial conduct of any sort, and with any individuals. In short, Mr. Youngblood has not conspired with anyone at any time regarding the metrics of this case, period. Plaintiff's theory is wholly undermined by the fact that Mr. Youngblood has not made any demands upon, much less engaged in any direct or any indirect settlement discussions with the plaintiff. Okay, so there was again, demand letter. So, this is sort of weak that they're standing on. Number 68, he denies, um, to the extent the response is required, not only the defendants without sufficient information or knowledge, and either admit or deny the allegations contained in paragraph 68 as to the awareness of and any statements made by some unknown conspirator, further denies that Youngblood has not made any demands upon, much less engaged in direct or indirect settlement discussions with the plaintiff. Same thing. Okay, 69. The defendant not only is defendant without sufficient information or knowledge to either admit or deny the allegations in paragraph 69 and the alleged conduct engaged in some unknown conspirator. Number 70, he denies plaintiff cannot possibly be entitled to damages because there is no liability. So again, like we were saying, he's denying it. Says, the defense to defamation is the truth, and his client, Duane Youngblood, is telling the truth, so there is no liability. Okay. So number 70, he denies to the extent, okay, he denies being liable to the plaintiff. Number 72, um, to the extent the response is required, plaintiff cannot possibly be entitled to damages because there is no liability. He's repeating this. Same thing. Number 73. Number 74, you all know these lights, these new lights I have. They just have you hot, 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 hot. Oh, okay. All right. So now to the affirmative defense. The first affirmative defense is truth. Plaintiff complaint fails to state the cause of action. Defendant statements are true. The second affirmative defense, absence of harm. Plaintiff claims fail, a absence of harm. Third affirmative of defense, waiver. Youngblood asserts waiver as a affirmative defense excuse me, to the defendant's claim. Fourth affirmative defense, consent. Youngblood asserts consent as the affirmative defense as the defendant claim. And the fifth affirmative is qualified privilege. Youngblood asserts qualified privilege as an affirmative defense to defendant's claim. And there you have it, ladies and gentlemen, the certificate of service. Also, again, like I said, this Sumner, Brad Summer, is the one that's filing this, and Ellis, the Sumner Law Group, and that is the one. He is counsel for the defendant. Remember, Blackburn was pro hoc vice to Youngblood in the state of Pennsylvania, because he is licensed in New York, had to come under a different law firm. He came under this law firm. And in order for this law firm to maintain and uphold their reputation, now they have to step in to defend Youngblood in this case so that their license will not be at jeopardy. Because at this time, if you look at the last video we did, it appears that Youngblood's attorney, Blackburn, license is in jeopardy. There's this case, this part of the thing is really sort of, which people don't say is exciting. The next one should be more exciting because of the nature of the filings. But again, we are not, we're not a gossip channel. I know some people, they expect, all of this commentary, and we're going to take this person's side, and we're going to call this person this, and we're going to call this person that. No, that's not what we do over here. We do news, and we also, comment on these law cases. And when we follow a case, we try to be fair and balanced. We don't try to have a dog in the fight. So it is what it is. We read the case. It just, confirm or deny. It is what it is, but we're not going to make anything up, and we're not going to sensationalize anything just to get a click and a view. We're not a clickbait channel, and so it is what it is. So anyway, the description, the playlist is down in the description, and you all can follow. And like I said, the other two dates that's coming up is going to be more exciting because of the fact that the judge steps in again, and Blackburn has to answer some serious legal questions regarding his filings. So anyway, make sure you like, share, and subscribe. We hope you continue to watch us, and we appreciate your time. And you all have a very blessed day. Bye. Getting bored? Want to enjoy some relaxing music? Do you need to get updated with all the latest news but don't have enough time to watch TV for hours? Or do you need to get your praise and worship on? We have your solution to your problem. SAVEDnewsRadio.com got everything you need. Listen to SAVEDnewsRadio.com, filled with praise and worship 24/7, everywhere, in your home, laptop, or tablet, on your phone, in your car, and on Alexa. Install the Save News Radio skill on Alexa, and then just say, "Alexa, launch Save News Radio." The beautiful, uplifting sounds of praise and worship music, ministries, news, and more. SaveNewsRadio.com, created to glorify God and edify the body of Christ.